Hello, this educational video is brought to you by the Colorado HOA Information and Resource Center. The topic of this video presentation is Initial Board Member Duties. Know your community and be familiar with the physical nature and status of the association. The information provided during this presentation is for educational purposes only and is not meant to provide or to be construed as legal advice. Any legal questions should be directed to your attorney. Be familiar with the physical nature and status of the community. It is important for members of the HOA board to be knowledgeable about the nature, makeup, status, and workings of the community that they are acting on behalf of. Common Interest Communities, also known as CICs. So what is a Common Interest Community? A Common Interest Community is defined in the Colorado Revised Statute 33.3 sub 8 as real estate described in a declaration with respect to which a person, by virtue of such person's ownership of a unit, is obligated to pay for real estate taxes, insurance premiums, maintenance, or improvement of other real estate described in a declaration. A CIC is the legal term used for an HOA. The Colorado Common Interest Ownership Act, also known as Kiowa, requires that the declaration of a common interest community state whether the CIC is a condominium, cooperative, or planned community. HOAs are also required to provide this information when registering with the HOA Information and Resource Center. The distinction in the Kiowa law between condominiums, cooperatives, and planned communities is made on the basis of ownership of real estate, not on the physical characteristics of the CIC. For instance, it is certainly possible for a CIC that resembles the one described under condominiums to be a planned community, or vice versa. What types of units are there in a common interest community? Pursuant to Colorado statute, there are three types of common interest communities: condominiums, cooperatives, and planned communities. A condominium is a common interest community in which real estate that is not designated for separate ownership by homeowners is owned in common by those homeowners. Many CICs designated as condominiums contain one or more multifamily dwellings, each of which is further divided into multiple units. Much of the remaining real estate is owned in common by all homeowners. These parts are called common elements. What is a cooperative? The least common type of common interest community is the cooperative. In a cooperative, the HOA owns the real estate and homeowners are granted exclusive possession of a unit on the basis of ownership in the HOA. One's ownership is usually exhibited by owning shares in the cooperative corporation. A planned community is simply defined in the law as a common interest community that is neither a condominium nor a cooperative. However, a planned community may contain condominiums or cooperatives. Commonly, CICs registered as planned communities encompass many single-family houses, each of which is equivalent to a single unit. The structure of the house and a small surrounding area are owned exclusively by the homeowner. Timesharing is a form of ownership of a unit, or more specifically, a timeshare unit, which is divided temporally, which means divided by time, creating timeshare estates. Definitions related to timesharing can be found in Colorado Revised Statute 38.33.110, which is a section of the Condominium Ownership Act, which precedes but is not entirely superseded by the Kiowa law. Common elements in an HOA. The Colorado Common Interest Ownership Act, Section 38.33.3.103, Part 5, defines common elements in a common interest community. In a condominium or cooperative, common elements are those portions of the community other than the units. In a planned community, any real estate within a planned community owned or leased by the association other than a unit are considered common elements. These common elements commonly include swimming pools, streets and sidewalks, a clubhouse, landscaping, and other common areas that are available to all owners in the community. Limited common elements in an HOA. HOAs also have common elements that are defined as limited. In the Kiowa Law, Section 3833.3208, subsection 19, the law defines limited common elements in an HOA. Limited common elements can best be described as a portion of the common elements allocated by the declaration or by operation of other sections of the Kiowa Law that are used for the exclusive use of one or more units, but fewer than all of the units. Limited common elements commonly include those elements that are directly connected to an individual unit, such as outer doors, windows, shutters, porches, patios, deck or balcony, a unit's driveway, garage, mailbox, or attic, and other features designed to serve a single unit, although located outside its boundaries, unless the declaration says otherwise. Also, unless the declaration says otherwise, ducts, wires, bearing walls, and similar fixtures which straddle a unit boundary are limited common elements to the extent they serve only one unit. Pre-Kiowa versus post-Kiowa communities. There is a distinction in the law concerning what we call pre-Kiowa communities and post-Kiowa communities. The Colorado Common Interest Ownership Act, Kiowa, came into effect on July 1, 1992. A pre-Kiowa community is one that was established prior to that date and is not thereafter elected to have the community be treated as if it were created after June 30, 1992. If a pre-Kiowa community has not elected to be treated as a full Kiowa community, then not all portions of the Kiowa Law apply to that community. For a post-Kiowa community, the Kiowa Law applies to all new common interest communities created within Colorado on or after July 1, 1992. Most of the Kiowa Law, with a few exceptions, applies to these communities. Common interest community exemptions. There are also some exemptions in the Kiowa Law for certain CICs. Some of the exemptions in the Kiowa Law apply to large planned communities and also small or limited expense communities, as well as numerous exemptions throughout the law for timeshares. As a board member, you should be aware of the owner makeup and needs of the community. Some communities have a wide range of needs in order to accommodate its owners. Some communities consist of a wide range of generations. What is the makeup of your HOA community and what are its needs? There are a wide range of generations to consider, from post-war to baby boomers to Generation X, Generation Y, millennials, and finally Generation Z. Does the community have families with children? Does it have accommodations for children, and is it attractive for families? Or is it a 55-plus community, which is a type of community designed to accommodate people that are at least 55 years of age or older? In general, in that community, the atmosphere, layout, and amenities are meant to provide for the needs of this age group, rather than, for example, younger families. The U.S. Department of Housing and Urban Development's Housing for Older Persons Act, HOPA, is a 1995 legislation that governs senior housing in 55-plus communities. It addresses key aspects of the rules surrounding senior housing economics. It was designed to provide affordable housing and safe living arrangements for qualified senior citizens. It is technically an age exception to the Fair Housing Act. In order for a 55-plus community to qualify for HUD senior housing support, it must satisfy three requirements. First, at least 80% of the units must have one occupant who is older than 55 years of age. Second, the community must publish policies and demonstrate its intention to be a 55-plus community. Finally, the community must verify the ages of its residents in order to remain eligible. This has been an educational presentation from the HOA Information and Resource Center. Following this presentation, you will find a short quiz and some HOA resources. Thank you for watching.